or what I would be as a prosecutor trying to say what's relevant is what happened at that moment, at that particular point in time. That what occurred prior to that and who got the better of whom or whatever didn't make a difference, that she did not have a reasonable, in fact, that's more of a reason to believe that she didn't have a reasonable belief that she was in serious fear of serious bodily injury or death. So I don't know how that plays out, but what shocked me about this case is listening to you and Judge Ashley just prior to the break. The prosecutors and defense lawyers, especially the prosecutor, would be well advised to listen to both of you debate the facts of this case. Because if I were prosecuting this case and listened to the both of you, I would be very unnerved right now because you guys are bringing up excellent counterpoints and the government's got the burden of proving this case beyond a reasonable doubt. You guys did a great job. It's unknown how these things are going to flesh out with the jury.
And this is why we invite Bob Bianchi back time after time.
Checks in the mail.
Seriously, because you do know, and I have to pick your brain, because if someone comes into you as a defense attorney, how do you determine strategically and factually if it's appropriate in your mind to say, yes, this is a self-defense case and we're going to pursue that?
Well, I mean, first you have to, like anything when you're trying to prove it, is you think backwards. You start from what you want to be able to say to the jury in summation. In this case, you're asking me the self-defense claim. And then I work backwards in terms of developing the factual elements and proofs that would be necessary. Previous history of domestic violence, as we're talking about, and the relevancy and admissibility of that evidence, as well as what went on at that particular point in time, because that is what's most important, as I just indicated before. At that moment, was the belief reasonable? It's not just that you felt you needed to use it. The jurors have to find subjectively and objectively that the use of that force was reasonable, the use of deadly force. As a defense lawyer, what is going to be a factual argument that I said before that is very relevant to me is that this shot was chaotic and there wasn't a lot of them. And it was more of a disorganized thing. And this whole thing with the ME, with all due respect, opining about, how the bullet went in, where it went in, and the manner. I've been listening to this for 30 years of people coming in and giving this kind of testimony. I haven't seen it, so I don't want to disparage it. But a million body mechanic and body engineering things can happen in a given instant. So to me, that's not that relevant. So as a defense lawyer, I'd be bringing up the previous history of domestic violence on that particular day, and that once the threat was eliminated, she stopped.